This is a session which will last about 25 minutes on managing ill health. That's sickness absence in the workplace. I'm Liz Burley. I'm presenting the webinar today. I'm from Burley Law Limited. We're a niche law firm covering employment law, HR and IP and commercial types of law. So that's me, and you'll get my contact details at the end of the webinar. Let's move on. Thanks, Simon. So today I'm going to cover not everything in all detail. Obviously, this is a massive subject and I can't drill down into every issue that we're going to cover, but I'm going to give you an overview of the legal framework we're dealing with when we're thinking of managing ill health and sickness absence. I'm going to think about two different types of absence and how they're managed differently, short-term and long-term. And I'm going to cover some practical tips for smaller businesses. Now, we're not in massive corporations. I don't think we've got anybody from Tesla here or whatever, but we're in small businesses in this session. And I myself run a small business, so I'm aware of the issues that this creates for business owners. So we're going to focus on SMEs today. So let's get started. So the legal framework for ill health and sickness absence is governed by two distinct pieces of legislation. And we're thinking about managing the absence here, not necessarily the pay that people get. But in terms of pay, there are statutory requirements. Then that's to pay statutory sick pay, which currently is from day 4 of absence, but is going to change. We're going to go down to day 1 of absence. That's been well documented in the media, and that will be coming down the line once the Employment Rights Bill is passed. We think that's going to be either in the summer, but more likely in the autumn now. And there are written requirements for written terms on sickness absence. So employees and workers are entitled to know what they will get paid if they go off sick, and that must be included in a written statement of terms. Now, the two key pieces of legislation for managing absence come through the Equality Act and the Employment Rights Act currently. Now, just touching again on the Employment Rights Bill, that includes a change to unfair dismissal. We're going to see that right to claim unfair dismissal go down to day 1 of employment. That's a huge seismic change in the employment law landscape, and it will affect managing ill health absence. So just touching on disability discrimination in the Equality Act, people who have a long-term health condition, whether that's mental or physical, that affects significantly their day-to-day life, their ability to carry out their day-to-day activities, including work activities, may meet the definition of disability under the Equality Act, and therefore may have protection from discrimination. Well, what's discrimination? It's less favourable treatment, inconsistent treatment, being put out of work, being subject to a detriment, like not being being demoted or not offered opportunities in the workplace. So it's very important that if you are dealing with either short-term or long-term absence, it can be relevant to both. If you're dealing with an individual who has a known long-term chronic condition, whether that's mental health related or a physical condition, and in some cases, some health conditions or disorders are automatically deemed to be disabilities. Cancer is one of those. It's very important you understand your obligations under the Equality Act, particularly your duty to consider reasonable adjustments. I'm not going to go into that in too much more detail in this session, but you need to have that in your mind. And then more widely then, under the Employment Rights Act, the law on unfair dismissal. So anybody currently with 2 years or more of continuous employment in the same job with the same employer has the right to claim unfair dismissal if their employment is brought to an end, if they're dismissed. We use language like let go, terminated, shown the door. Any of those will count as a dismissal for the purposes of unfair dismissal law. And as an employer, you will be under the spotlight if you receive a claim, notified of a claim by an employee who's been sacked for sickness absence, long-term or short-term. the onus will be on you as the employer to defend it, and you'll have to go through a number of hoops to do that successfully. One is to show that you have good evidence of capability to justify a capability dismissal, and the other is to demonstrate that you have carried out a fair process in order to arrive at that decision. So if you have employees with over 2 years, you must tread carefully when you're dealing with both short-term and long-term absence. But don't forget that under 2 years, currently, you still need to be mindful of that disability discrimination risk. Obviously, when the Employment Rights Bill comes into effect later in the year and that day one unfair dismissal right comes into force, you're going to have to be much more careful from day one of employment. Next slide, please. So I'm going to turn to look at managing short-term absence. And what do we mean usually by short-term absence? Well, there's no legal definition, but it's generally regarded, and certainly ACAS guidelines indicate this, that it's anything under 4 weeks. And it's usually going to look like a day off here or there, not continuous absence, although somebody might go off, be signed off by their GP for a short term of absence that might look like 4 weeks or less. But typically we're thinking about those days here or there. And it might be that that individual has some underlying issue. Usually it's indicative of an underlying issue. It might be that they're having difficulties in the workplace. They've got difficult relationships. There's some kind of grievance brewing. It might be that there's a personal underlying issue that's at play that we need to get under the skin of. It just might be that they're unable to organise themselves to get into work on time, and it might be that they're slipping under the radar and having what we used to call duvet days. Although I acknowledge that I think this problem, anecdotally, is probably not as prevalent as it used to be before COVID. Why? Because many businesses have introduced remote working. People are able to work from home or have other flexible working arrangements that give them a little bit more latitude in life. That means that they're not having to resort to sick days to manage their life or personal situations. So that is something to bear in mind, but it still can be a tricky issue for SMEs to deal with. Why? Because it's disruptive. It can be costly if you've got company sick pay arrangements, and it can really start to bite if it goes on for any period of time. So the thing to do with short-term absence is to ensure that you have return to work interviews, meetings. Keep your records in top tip order. Have individuals complete a self-certification form for any absence of where they can self-certify of up to 4 days and beyond, up to 7 days, and beyond that, a GP fit note. Make sure that you follow your process that requires that consistently. Make sure that your employees understand the process. Many of them won't have any idea what your absence policy says unless you bring it to their attention. It might be hidden away in an employment handbook that's several hundred pages long, full of other policies. You need to make sure that your employees understand the process that they have to follow to notify you if they're going to be absent, and also the requirements in terms of paperwork on them and anything that will happen on the return. That's good for managing expectations. It also ensures that people know where they stand. Now, there may be a misconception that you can't dismiss somebody if they go off on short-term absence. Well, that's not correct. Dismissal is possible, and usually it'll be a dismissal on capability grounds. Why? Because we're looking at somebody who's not able to sustain the regular attendance at work that is required for your business. Now, there are no hard and fast rules on what a capability dismissal looks like and when too much absence, when absence becomes too much for your business. It's up to you to decide and set those rules. Many larger businesses rely on the Bradford factor and trigger points, and they have processes around that, and they can be very, very strict. I once dealt with a case for the post office where I was defending a claim of unfair dismissal. I was acting for the post office, and one of their postmen back in the 90s had unacceptable absence levels. They were sacked after warnings, but those absence levels were relatively low, amounting to probably less than 10 days in the year. Now, Post Office is a large organisation, but it has a large workforce and it had a sickness absence problem that it was trying to manage. In all those circumstances, the Employment Tribunal decided that that dismissal was fair. So when we're looking at unfair dismissal law, tribunals have to assess fairness on the basis of the size of the organisation and the administrative resources available to it. You, as a small business, will not be judged in the same way as Facebook or Meta or any large global corporate or any large public sector organisation, but the tribunal will want to know why your triggers are set at the level they're set at. Again, making sure that your employees understand the triggers is key, and monitoring is key. You're looking for patterns sometimes of short-term absence. So what is the pattern? Is it some same day every month? Is it around a particular event that might be happening, or a customer demand or pressurized time in the business? Is it something that's happening in the employee's personal life, their personal situation, their personal health, that's affecting the cycle of absence? And what is absolutely important and fundamentally important with any kind of absence, if it's short term like this, is getting to grips with the issue early. Having early conversations, getting in and understanding the problem is fundamentally important to managing it forward for being optimistic, hoping for success, turning it around, getting the employee to get more reliable with their attendance, stamping out the casual days here or there, and even more importantly, planning for the worst case scenario. I have lots of experience of helping businesses who come to me quite late in the day, where absence has gone on and and it's gone on, and it's been left to fester, and the employer comes to me at the end of their tether. We can't go on like this. What can we do? This individual needs to go. That is not the point to start, the point at which or the time to start planning for a process. That must be much earlier on in the absence pattern. And if you start working with an HR advisor or a lawyer early on, you can start managing the process, managing the communications, getting your paperwork in place so that you have a sound footing and framework on which to then start issue warnings under your absence policy, and those warnings inevitably leading to dismissal if things don't improve. So it's much like dealing with any other poor performance issue. Now, I'm going to just touch very quickly on dealing with malingering, because if you have a malingerer, and by that I mean people who are using sick days dishonestly, who are not actually sick, who say they're sick, it can be very difficult to get to the bottom of that and to get good evidence. But if you suspect malingering, the typical things that you need to look for are evidence. If you want to go forward on the basis that you're going to sack this person for malingering, you would have to deal with this as a misconduct issue under principles on unfair dismissal. You can't treat it as capability. It has to be called out for what it is. If they're over 2 years, you must then go through your disciplinary procedure, not your capability procedure. You must issue warnings for misconduct, not capability. So that's a whole other ball game, a whole other nest of vipers, requiring a different kind of approach, different kinds of evidence. It'll be evidence of the misconduct, of the dishonesty, and you'd have to be dealing with that through a disciplinary process. Next slide, please. Managing long-term absence. This is a completely different set of principles and a different approach to managing short-term absence. I'm going to think about two different scenarios here. The first is genuine, understood medical condition or illness or a need for absence that's around either an operation, surgery, or some kind of treatment that the employee has to undergo. Everybody understands what is going on in that scenario. There is certainty and the business can plan. It's not ideal. And if there's a company sick pay policy that pays more than statutory sick pay, then obviously it's going to be costly. But it has a limit on it in terms of time. That is an easier situation to manage and much more straightforward than this next scenario. Your employee is put through a grievance or a disciplinary process or a performance management process, and in response to that goes on to ongoing open-ended sickness absence, usually citing mental health problems, stress, anxiety, depression. That scenario is much more tricky to manage. It's much more tricky to bring to an end, and it's much more difficult to resume your HR processes that they've gone sick in response to. The first scenario, then, I think we're going to just put to one side. Obviously, some general principles apply to both of these scenarios, and in terms of good HR practice, you should, of course, follow. So keeping in touch with the employee. Be much more easy to do with somebody who is on a managed sickness absence, planned certainty over time, and there is an expected recovery plan, which everybody knows about. However, if things start to go wrong and that employee needs longer term absence, stays off, and the recovery isn't as expected, then obviously some of these other principles will come into play. But keeping in touch is fundamentally important. Having a plan to keep in touch, understanding from managing the employee's expectations about how and when those keep in touch phone calls or meetings will happen, and then planning for the return is fundamentally important. Anybody who's been out of a business, out of their job for a period of time will need to have a carefully managed return to work, and it might be phased. And don't forget, of course, the disability discrimination risk, and phased returns to work and adjustments to duties during a phased return to allow for successful return to full-time and full duties will be considered to be reasonable adjustments if that employee has a long-term condition that's likely to meet the definition of disability under the Equality Act. So going back to our other scenario, so unplanned long-term absence. Typically, that's going to be over 4 weeks. So somebody may be signed off by their GP for depression or anxiety for that period of time, or for longer. In my experiences, GPs don't sign off immediately for more than 4 weeks because they have a system whereby they review the patient after 4 weeks if this is a first instance of anxiety or depression. But other than that, you may be facing, for a second sick note, you may be facing a period of 2 months or maybe even longer. So in that scenario, yes, of course, keeping in touch, you may face difficulty getting the employee to engage if there's an underlying workplace issue that is outstanding. But all efforts to engage with and get updates from the employee will stand you in good stead if things do ultimately come to the worst case scenario. So the key steps to managing long-term absence, where there's a possibility now of dismissal, are to explore alternatives before you get to dismissal, getting and keeping medical evidence up to date. And that might be medical evidence from the individual's doctor or treating clinician, if you know they have one. Or it might be an occupational health referral by the business to get their own medical advice here. And particularly that's going to be important where you have an employee who's saying, I'm too ill to work, I'm too ill to engage with a disciplinary or performance management process. You need advice from an occupational health practitioner on that individual's fitness, not only to work, but to attend meetings in the process. And then you can take decisions about whether you carry on with the process, whether that's in person with the employee if they're fit to attend, or without them. And that can sometimes be a possibility that's fair in circumstances where you need to be able to progress a process for the good of the employee as well as for the business. Follow a fair procedure, follow your absence policy, and consult with the employee at key intervals, at key moments in that process. The basic principles of unfair dismissal are usually that an employee is not dismissed without being consulted for capability, and that's usually in a face-to-face meeting. However, reality suggests that if you've got somebody who's off sick who won't engage or is saying they're too ill to attend, you may have to go ahead and make a decision in their absence. But it will be fundamentally important in that scenario that you have attempted to get their input in writing before you come to make that decision. So no haste here. It has to be a well-planned process, and you have to be able to show to an employment tribunal that you've gone through a proper consultation with the employee before you reach the end point. Be aware of obviously the risks around unfair dismissal and discrimination here. As I mentioned, reasonable adjustments earlier. relating to phased returns to work, adjustments to work duties and demands, possibly hours of work, place of work to enable return to work. But also reasonable adjustments can kick into decisions around dismissal if there's any suggestion or any advice in an occupational health or a medical reports that there may be a need to wait a bit longer, or there may be a need to understand employees' fitness to work after further treatment or adjustment to medication, for example. So reasonable adjustments is a very broad concept. It doesn't mean one thing in all scenarios. Next slide, please. Some practical tips here, which may seem very obvious, but they're important. Have a clear and accessible absence policy. Make sure that it's not hidden on SharePoint, that people know where to find it. Send it to employees. Don't just rely on them looking at it in the employee handbook, and follow it consistently. This second point, I think, is the most important of all, and in my experience, the one that lets smaller businesses down. Line managers need to be trained on handling absence processes and on handling communications with absent employees. Very often, and if you were to go and look at any case law on unfair dismissal around capability dismissals, it's often the communications that let businesses down. That can be an over-aggressive approach. It can be a lack of understanding. It can be an absence in documenting communications. It can be gaps in meeting, the process, failure to have a meeting, failure to consult. So those processes, the paperwork and the communications that need to feed into them are fundamentally important to being able to manage risk and defend claims if the worst comes to the worst. And at every turn, keep accurate records. Don't forget that medical data is sensitive personal data, and we now call it special data for the purposes of data protection law. So handling that data, handling those records and the information in them must be done in accordance with the Data Protection Act. So not overly shared, kept secure. If you're planning to share with any third parties like occupational health, you get employees' consent. And only those people that are relevant to the process of managing the absence should be involved in handling those records within the business. Next slide, please. So some more practical tips for you. Obviously, there's a very big emphasis, particularly nowadays, much more so than when I started out in business back in the 90s. In 2025, empathy is hugely important. Demonstrating empathy is hugely important, and balancing that with the needs of the business. But ultimately, the needs of the business are paramount and need to be communicated well, and they will be the thing that drives the process ultimately. And employment tribunals are not people who sit in ivory towers. They understand business needs, and they will be sympathetic to your business case for dismissal, provided you have taken the right approach to dealing with it. I've added here, consider insurance. It's not affordable for every business, but bearing in mind that most SMEs pay SSP only, they don't pay company sick pay for lots of good reasons. There may be an affordable alternative in income protection insurance. Insurers are, in my experience, very happy to have conversations. You may find that you can buy an affordable policy for your employees that gives them some protection during times of sickness. But obviously take insurers' advice on that. And the last one is to take legal advice to assess risks. Where you have any employee that's gone off open-ended, long-term absence, or where you're dealing with a problem involving short-term intermittent absence that's persistent, take legal advice, particularly over that unfair dismissal threshold of 2 years. And finally, my top tips. Clear and easy to follow absence policy in place. If you haven't got one, get one. Make sure your managers are trained. If they're not, we can offer some basic training for management on handling absence effectively. You can get all sorts of resources out there from ACAS and other organisations, and there are plenty of videos out there on YouTube, obviously. but your managers need help to manage this effectively. It's not just down to them. And it will be line managers who are in the front line here. And those line managers will be the people who are hauled in front of the Employment Tribunal to give evidence. So to be fair to them, they need the right toolbox to be able to do this job effectively. Show empathy, but keep in mind your business needs, and short staffing and client demands, customer delivery are absolutely paramount in all of this. Keep your detailed records to protect the business and make conversations down the line easier to have. And that, I think, is all I have for you. There are some useful resource links here. They're not live links, but we will send these slides out to you. I've mentioned ACAS. I'm also going to mention now our YouTube channel. There are valuable resources on there, such as webinars that we've done previously and podcasts that you can listen to. So go to our YouTube channel. Please like, subscribe, comment to help our engagement. And after this webinar, you're going to get from me a couple of free resources. One is a flow chart that helps you understand notice pay where your where employment is ending and somebody's off sick. It can be quite complicated. There's a weird rule around notice pay and how it's paid, which often businesses don't know about. So that flow chart will help you with that. And there will be a letter that helps you to communicate what the arrangements are for sickness during holidays. I haven't touched on that in this webinar, but if you go to YouTube and look at my webinar on holidays and managing them, you'll find something on that in there.